Is it up?
Not yet. There, it's up. Okay.
Hi everybody, welcome back to the Scott Wagner Law live streaming video on Facebook Live. We're here to answer all your questions and concerns about COVID-19 as it relates to the new statute that was just passed relating to the Family Medical Leave Act and expanding sick leave and paid sick leave for many of Americans. Welcome. Just going to allow a few moments for people to join. Okay, so we prepared a slide presentation for you to hopefully walk you through some of the finer points of the new statute that was just passed. So I'm Kathleen Scott. I'm the managing partner of the Scott Wagner Law Firm, board certified in labor and employment law, and I'd like to take you through what President Trump signed into law just as recently as last night. One caveat as we get started, this is brand new. So as I'm saying things today, there might be finer points on the interpreting legislation that comes out that may answer some questions. So I'm going to give you my best shot and my best legal advice on what the bill says today and the three biggest parts that apply to you as a business owner and to all those millions of employees who are out there looking at being on sick leave. So we're going to talk about the Emergency FMLA Expansion Act, the Emergency Unemployment Insurance Stabilization Act, and the Emergency Paid Sick Leave Act. Please note that I have not covered in these materials today anything related to collective bargaining agreements, and there are specific provisions in the statutes relating to bargaining agreements. Okay, so we know that the Emergency Family Medical Leave Act was passed last night. It is going to take effect April 2nd, and it will last until December 31st. So this is intended to be a temporary emergency paid sick leave act. It amends the Family and Medical Leave Act, or what's also known as the FMLA, which typically only applies to employers that have more than 50 employees. However, Congress has changed this provision of the FMLA to apply to every employer that has less than 500 employees. And I put the language up on your screen there. The term employer means any person who's engaged in commerce who employs fewer than 500 employees. So anybody out there who works for an employer that has less than 500 employees, has more than one, and is engaged in interstate commerce, this law applies to you. My employers that are out there, small employers, small businesses, this will apply to you as well. I will tell you that in the statutory language, there is a provision for the law to apply for a waiver. The Department of Labor can execute a waiver, and we'll go through that in a little bit more detail. But you should consider that this law does apply to you until you're otherwise waived out of it. There's also no procedure or provisions in place for how to accomplish that waiver just yet. So the Department of Labor is the individual agency that's in charge of interpreting the statutes as it relates to labor law in our country, and they were going to do that as well as it relates to this one. There is a provision that if you have a business with 50 or more employees, that you might be eligible for a waiver, but we don't know today what the requirements are for that waiver, and we don't know the procedure to get that waiver, or whether there will be particular requirements. So for today's purposes, I think you should assume if you're in a small business or any business, this applies to you. So what does it mean? It means that if an employee is out sick, the first 10 days of that leave are going to be unpaid. During this time, if the employee has paid time off or other types of accrued leave that your business offers, then the employee will be able to use that paid time off or PTO to pay for those first 10 days that the employee missed. The employee can elect to substitute their accrued leave. This is an interesting provision because it seems to be at the employee's election, not the employer's directive, which is a little bit different than how we've interpreted the FMLA previously. So first 10 days unpaid. Thereafter, an employer shall provide for paid leave for each day that that employee takes off after that initial 10 days. So employee goes out, first 10 days are on them. If they have accrued PTO, they can use that. If they don't, it's unpaid. After that, the employee gets to take off, if they qualify, and we're going to get into qualifying leaves in just a moment, then their leave is actually paid by the employer at 2/3 of their regular rate. So this is calculated by figuring out what their salary rate is per day, or by using regular hours up to a dollar amount of $200 per day. So to say that again, sick leave that the employer is paying under this provision should not exceed more than $200 a day or $10,000 in aggregate. A couple of final points. The Family Medical Leave Act in general will allow employees to take off up to 12 weeks of unpaid leave. This amendment says that some of that time, 10 weeks of that time, if they qualify for 10 weeks of leave, is going to be with pay, and it's going to be at a pay rate of 2/3 of that employee's salary, but not to exceed $200 a day or $10,000 in the aggregate. 200 times 10 is 10,000. So this is a dramatic change for small businesses who have not had to deal with the Family Medical Leave Act provisions before. This is going to be an expense for sure. And we'll get into tax credits at the end of the seminar, and how the idea is that this will cost less for employers. So they're actually get a tax credit. But what you need to know is if an employee qualifies and they go out 10 days unpaid, then up to 10 weeks of paid leave, provided that they qualify at $200 per day. So I created this little chart to try to help put it in perspective, just what we've been saying. First 10 days, if you have PTO, the employee can use it. Otherwise, they're unpaid. Thereafter, it's up to $200 per day for up to 10 weeks, according to the new COVID Emergency Act. So there's also a reinstatement provision under the Family Medical Leave Act. As it was originally enacted, it was signed into law, by a little point of background, in 1993 by President Clinton at the time. And one of the big points that the law was trying to accomplish was to keep it so that employees who had to go out and be sick due to no fault of their own would have a right to reinstatement. So the amendment also guarantees an employee a right to come back to their job. And there are a couple of provisions. So the employee has to use the leave for the purpose it was intended. So if an employee is taking the leave time to care for a loved one that has COVID-19, and that's the purpose of the leave, but it turns out that's not what they used it for, that they had another caretaker available, they just opted to stay home, that would be an argument. So in order to be eligible for reinstatement, the employee has to take the leave as intended, and the employer then must restore that person to an equivalent position with equal benefits, pay, and other terms and conditions of employment. So that means that the employer has to bring back someone who was a truck driver to a truck driver position, someone who was a mid-level manager to a mid-level manager position. They can't demote that employee when they come back. There are a couple of exceptions. These are worth noting and very important, particularly for small businesses. The employer under this new law does not have to reinstate to a substantially similar position if that employer has less than 25 employees. Now, the news has kind of convoluted and is very complicated a lot of these alphabet soup and numbers that are in this new amendment. So I actually read one article today that said an employer doesn't have to offer paid leave unless they have more than 25 employees. No. It applies for the leave time for everybody under 500 employees, but employers don't have to guarantee a right of reinstatement to a position if you have less than 25 employees, provided that you meet each of the 4 qualifications that I will go through. So the 4 qualifications: first, the employee has to take the leave during this emergency time period, sometime between April 2nd and December 31st. The position has to no longer be available. So if you have, in my example, of a driver, but no longer does your company offer drivers because of this economic crisis, the position is no longer available, that would be an example of, you would satisfy that prong of this particular test. And the reason the position has to be no longer available has to be related to economic conditions, or that the operating conditions of the employer have changed. Employers are making significant business decisions to eliminate entire departments. If that's the case, and that's related to the COVID-19 situation, then you'll be able to take advantage of this provision that does not require that you hold the right for reinstatement. But there's a kicker. So the employer has to take reasonable efforts to restore an employee back to that position if it becomes available and they have to continue to reach out to that employee for the shorter period of either an entire year after they went on leave or from 12 weeks from when the leave began. So obviously, if you terminate your entire department of your company and then you reinstate all those individuals within 3 months or 4 months, you have a duty to try to reinstate one of your workers who was out on medical leave during that period of time. So that's, in order to qualify for the reinstatement exception, you have to have an employer with less than 25 employees who meets each of these requirements. And just quickly, that means people who've gone out for leave related to this particular COVID crisis, individuals who establishing the employer had an economic condition or hardship changing their operating conditions, and show that you've made reasonable efforts to reinstate that particular person by reaching out to them should that position become available in the future. So those are the four prongs. I should mention that all of this is complicated, and so everyone would be wise before making these decisions to have a consultation with their labor and employment lawyer to help navigate through these issues. If the employee, so getting back to the other requirements, if an employee has not noticed that they are going to need to be on leave, they need to give the employer as much notice as practical. That's a very similar theme that we've seen throughout the FMLA. That just means if an employee, for example, knows that while their son and daughter's school might be open today, but they've been told that it might close in 2 weeks and there is no child care protection, then they should tell their employer now instead of waiting until the day before that 2-week period occurs, so that it is clear for the employer to have as much notice as possible. Okay, the next thing we're going to talk about, that's pretty much all the highlights for how the FMLA has changed, what we just went through. If you have 0 to 499 employees, this law applies to your business. And I think we just went through the elements of that. Next is another part of the statute that passed, which is called the Unemployment Insurance Stabilization Act. The only part of this that's relevant for my employers that are out there and employee clients is to know that it is the employer's duty to notify employees when you separate their employment, either for a layoff, a furlough, or termination, that you let them know that there is unemployment available out there for them. The provisions on how to do this, the details on what you're supposed to tell them is not out yet. That's going to be a notice by the Department of Labor, so stay tuned. I would say for now, if anyone is out there trying to make a decision to whether to terminate employees and how to do it properly, you should give them notice and direct them to the Florida Department of Economic Opportunity, floridajobs.gov, so that they can apply for unemployment compensation. So the next provision that was amended last night and signed into law is Section 5101, and that section requires employers to provide sick leave. Again, a whole new thing. This is a whole separate act. This is not an amendment to the FMLA. It's a separate provision. So it requires sick leave. In our state, Florida, where I am giving this from right now, there is no requirement to have any sick leave at all. For people who are listening in other states, that's different. For example, California and other places have mandatory sick time payments and employees have to be paid them out. That's very different. So this is going to be a big change for a lot of employers who don't currently have the obligation to provide sick time to their employees. So what does that employer have to do? That employer must now pay sick time if an employee is unable to work or telecommunicate because of any of the following reasons. Because they are quarantined or in isolation because of COVID-19, because that employee has been advised either by a healthcare provider or professional that they need to self-quarantine, that the employee is having symptoms and they are currently seeking a medical diagnosis, that the employee is caring for an individual who has been advised by a healthcare provider to either self-quarantine or is been told to locally quarantine, to locally isolate, they will qualify. If the employee is caring for a son or daughter who's under the age of 18 and the school has been closed or is currently unavailable childcare due to COVID-19, then they qualify. And the last one is if an employee is expecting any other substantially similar condition protected by HHS or the Department of Labor. That just means COVID might not be the only reason that could cause this employee to become sick. If one of those criteria is available, in quarantine, isolation, caring for someone who's in quarantine or isolation, actually sick and seeking a medical diagnosis, or the school is closed and you have to care for your son or daughter, then you qualify for sick leave. It has to be paid. Couple of interesting notes. This is a common theme throughout both the sick leave amendment as well as the FMLA amendment. The employer can exempt healthcare professionals or emergency responders. I'm not sure what Congress was thinking about that, other than to sort of just guess that it likely was because they want people coming to work, even if they have the sniffles or a cold, because we need those individuals to help with the overload on our healthcare system. But that is a notable exemption to both of these requirements. So how much do you have to pay out there, employers and employees? How much can you expect to get if you are in one of those situations where you're self-isolating or been told to quarantine or need to stay home to take care of your child because of COVID-19? Then your employer, if you're a full-time employee, must pay you 80 hours of sick leave at your regular rate. For any part-time employees out there, the employer must pay you basically your average weekly hour, looking in a backwards looking time period. Over a 2-week period. So full and part-time employees alike both get sick leave. So how much is it? We just talked about how much that is for full versus part-time employees. But paid sick time means, under the language of the statute, that it's going to be compensated leave, but it should never exceed $511 per day or $5,110 in the aggregate. So for the entire period of time of paid leave, the employer, for any one employee, should not pay more than $5,110. That's what it means. And so there are some additional nuances to that, but for our purposes here, if the employee is subjected to a state, federal, local quarantine, then they qualify, and these paid sick time increments apply. So that's what that means. Also, there's a $200, a lower per day amount, and $2,000 aggregate amount when that employee is caring for someone who is sick due to COVID-19 or caring for a son or daughter because they don't have childcare. So if the employee themselves is sick, then the amount is higher, but if they're there as a caretaker, the amount is lower. So it's $200 per day up to $2,000 a day for aggregate. And I should mention that I know I'm moving quickly and this is complicated. These slides will remain available up on our website for anyone who needs help. And again, this should always be done in consultation with your labor and employment attorney to make sure that you've understood all of the nuances. So some nuances and prohibitions that in the statutory language: an employee cannot carry over sick leave. So if they don't use their 80 hours, and then next year they say, oh, what about those 80 hours I didn't take off during the COVID-19 crisis? They don't carry over from year to year. The need for sick leave terminates when that employee returns to work. So what that means is if someone goes out sick for 2 weeks, they quarantine, they come back, they no longer have another 80 days. That's my interpretation of that. I think that's going to be one of the areas where we need a little assistance from the Department of Labor on that finer point, but that appears to be the way the statute reads at the current time. The employer cannot require an employee to find a replacement or cover that shift. So we are hearing these stories. I was getting phone calls about individuals who work as drivers, individuals to deliver, and say they get sick, saying, well, you can be out, but you've got to cover your shift. Waitresses saying, yes, you can be off the schedule, but you got to find someone to pick up your shift. That is not allowed under this particular provision. That is the employer's responsibility, not the employee's responsibility. So a couple of interesting points on that. An employer can also not require an employee to use their PTO before they take the sick leave. So I know I said under the FMLA section that the employee, the first 10 days were unpaid. It would seem to me that under this law, people who didn't have PTO then could use this sick leave provision to cover those first 10 days with pay. Although that is, quite frankly, something that the law doesn't really define or explain. What we do know is if you're operating only under the sick leave 80-hour provision, it's 80 hours. You can't require an employee to use other PTO before you, the employer, have to pay them that mandatory sick leave if they're out sick for one of those qualifying conditions. So we don't really know how COVID-19, the sick, and the FMLA leave work together, but one possible way, if you're an employer saying, how do I navigate this? I have someone who's sick, just tell me what to do. So I put together this chart to try to help you, knowing that there's going to be some finer points coming from the Department of Labor in the coming days. So if you're an employer who has less than 500 employees and you have an employee who's out and they're sick, and they qualify under one of the reasons that we've just discussed, they themselves are sick or they're caring for a loved one who's sick, then they can get up to the 10 days of sick time. Under the Sick Leave Act, that would be paid sick time. And that would cover the first 10 days. Thereafter, they continue on FMLA if they qualify, and you then pay them up to $200 a day, or 2/3 of their salary, whichever is less, up to $200 a day for the next up to 10 weeks of time, provided that they still continue to qualify. And then you need to ask and figure out whether you have a duty to hold that employee position open for them, and whether you have that right of reinstatement. And just as a refresher, only employers that are larger than 25 employees have a duty to keep the position open and guarantee a right of reinstatement, but they do need to meet those obligations that we discussed. Finally, an employer is also required to post a notice in a conspicuous place in their premises that tells employees about these rights that we've just gone through. The notice is going to come from the Department of Labor. They're going to identify the language. They've done this with the Affordable Care Act too, and that is due out in 7 days. So we should anticipate by next Thursday that the Department of Labor should have out that draft notice. Certainly, as an employer, you have a lot to deal with right now. Don't let this notice provision fall through the cracks. Typically, a notice works if you can put it in a conspicuous place. If you don't have a workplace, you can email it to your employees, or you can send it by mail if necessary. If you have employees that speak other languages, I would recommend strongly that you have the notice transcribed in those languages and send it to, that's applicable. Typically, the Department of Labor will post those ones for you as well. So, some other prohibitions in the law that just passed. It is unlawful for an employer to fire, discipline, or take an adverse action against an employee who takes the sick leave and takes advantage of the sick leave. That would be a wrongful discharge claim. It also is a violation of the act if an employee files a complaint or institutes a complaint and then suffers a retaliation. That would be considered protected conduct, and an employer should know that. An employee who feels like they're being mistreated in this regard should know that that is against the law. They're allowed to take this leave. They need to do so without being threatened or intimidated. They should feel free that their job is going to be there and that sick leave is something that's available to them. So there are violations, and I think this is worth noting because the violations of this statute, the way that it was written in law, it follows the Fair Labor Standards Act. So that means if there is any unlawful termination, then that would be considered a violation of the Fair Labor Standards Act, which is a law that allows for not only back wages, but liquidated like punishment damages, double damages usually, as well as attorney's fees and cost. So employers who are out there, please avoid any willful violations of the statute and take care. I know there's a lot to deal with. So if you're an employer and you're feeling a little overwhelmed, I do want to recommend a few just very basic things. First of all, if you don't have a current handbook or policy that relates to sick leave, you should get one. If you do have one, you need to make sure that it is compliant with what we're talking about here today, to make sure that there is that mandatory 10 days of pay, to make sure that you have adopted and now know about the temporary Family Medical Leave Act that's you're going to be required to offer paid time off for up to 10 weeks, even if you're a small employer. So employers, you got to look at your policy, post that notice, communicate with your employees to make sure they understand these things and that this is happening and they do have these new rights. So certainly we are here to help. We understand. We're available to answer your questions. So you might be asking, who's going to pay for this? That's a lot of sick leave. Businesses are closing. Businesses are struggling. The economy is struggling. Who's going to pay for all this time off for sick leave? Under Section 7001, employers get a payroll credit for the sick leave that they pay out. So employers shall be allowed as a credit against any tax imposed by the Internal Revenue Service for each payroll quarter, 100% of whatever they've paid as wages for qualified sick leave. So that is very important, and that is the idea how this is going to, quote, not come out of the pocket of the employer. As a practical matter, the employer will keep these individuals on their payroll, and then when their quarterly tax payments are due, be able to claim the amounts paid to these employees back as tax credits. The statute also says that credits are also allowed for increases in the employer's qualified health plan expenses that are properly allocated to the sick wage payments. So that's about as clear as mud. So that we're going to need a little bit of guidance from the Department of Labor. But fair to say, employers have some challenges ahead and some things to figure out in terms of how they can best advise their employees, make plans for the future on how they're going to arrange for this. Earlier today we had a question and answer session where we let people write their questions and call in. So I wanted to reiterate some of the questions that were from that previous program. And so let me just address some of those now. The most common one is people believing that this doesn't apply to them because they don't have 50 or more employees. And that is not true. As drafted, the statute does apply. The paid leave time does apply even if you are a small business. And there are a lot of individuals asking, what if I already give my employees 80 hours of sick leave? Have I then complied with the law? And the answer is yes, you have with the Sick Leave Act, but you also need to consider whether that employee needs to be placed on an FMLA status for this temporary coronavirus period. Another question that was asked, and frankly I don't have a good answer to it yet, is whether this Sick Leave Act is going to be temporary or a permanent change to employers, and something to keep in mind as they do their policies. But we don't have clear guidance on that just yet. In part, even the statutory name sort of suggests that it may be a temporary change. That's something that we hope to get a little bit more clarification on from the Department of Labor as they ensure the enabling legislation. So what we do know is that it's called Emergency Paid Sick Leave Act. It is Section 5101. There is a sunset on part of the statute. It is unclear whether that sunset provision, which ends this in December of 2020, includes this particular aspect of it. It may not. And so I think for planning purposes, it's a question mark and one that needs to be resolved. It appears to be that the FMLA portion of it, no question, has a sunset provision. And that is until March 31st, 2020. I think you can, one reading of that would be to say yes, that all the changes are temporary. I'm just saying cautiously that may not be the way everybody interprets this issue. So I'd like to thank everyone for their time and let them know that the Scott Wagner Law Firm, we're here to help you navigate through this time. If you have questions, if you're an employer that needs a sample policy or needs help reviewing your policy to adapt to these changing times, we have a very efficient and cost-saving way to do that. We're just charging a consult fee. We get on the phone, we answer your questions, and then prepare whatever documents that you needed. We're trying to be like urgent care to the employers who are navigating through this difficult time right now. Also for employees out there, if you have questions about your rights and remedies, please, all of you, feel free to give our office a call. We'll continue to do these webinars and these Facebook Lives until everyone has a clear understanding, hopefully, of the statute. We do have another one scheduled for tomorrow. If you email us your questions, we'll be happy to address them individually as well. We do have offices not only in Florida, but also in California. So employers and employees who are listening, who are bi-coastal, we can help you, as well as many other employers across the state and across the nation. We do have a nationwide practice. So thank you, everybody, for your time. Stay well, be well, and we all are here to help if you need us at the Scott Wagner Firm. Thank you.